on to our next speaker. He is an advocate on record at the Supreme Court of India, Sridhar Potaraju ji. He's an accomplished advocate on record hailing from Hyderabad, Telangana. He boasts of an illustrious legal journey spanning over 2 decades. He's a distinguished alumnus of Osmania University, and he's honed his legal acumen at the Campus Law Center. With a rich background in research, he commenced his career at renowned law firm MS Lakshmi Kumaran and Sridharan, delving into indirect taxes. Guided by the eminent Sri P.S. Narasimhaji, he gained exceptional experience at the Supreme Court of India. Transitioning to independent practice in 2002, he earned the coveted position of advocate on record in 2006, showcasing his mettle. Potarajuji's legal prowess encompasses intricate commercial litigation encompassing infrastructure projects, IP rights, environmental laws, and technology sector consultations. A pivotal figure in landmark cases, including the Sri Rama Janmabhoomi case, where he was part of the core legal team, and significant judgment on Hindu women's property rights. His expertise extends to issues concerning Sanatana Dharma before the Supreme Court of India. He is also an avid learner of wisdom from the Itihasas and the Puranas, as demonstrated by his book, Maxims from Mahābhārata. Moreover, his insights have found expression in notable publications, including Dharma in the Atman of Civilizational and Cultural Heritage of India in News 18, Deconstructing the Legalese of Demonetization 2016 in Legally Speaking, The Sunday Guardian, and enlightening articles such as The Marxist Spin to Indian History Unearthed in the Sri Rama Janmabhoomi case, published in Swarajya in October 2020. With that, I welcome Sridhar Garu to speak on the topic that he has chosen for us today at this symposium. He's going to be speaking on Dharmasankata, dilemma in decision making. And he's just one example of how we have diverse voices in this symposium. So we will hear now from a legalese. Go ahead, Sridharji.
Namaskar, Gurubhyo Namaha. I would like to take this opportunity to thank INDICA Academy for their relentless efforts to bring people like us onto a platform where we can learn and hear scholars. Otherwise, in our mundane life, we are unable to reach out to most of the people that we hope to learn from in our earlier stages of life, probably, which could have been much more useful. Be that as it may, now that we are where we are, I think it's never too late to learn, and that's the spirit with which I join in this. I would like to commence my speech with this, acknowledging the speakers prior to me have actually substantially covered the issue from the Itihasas and the Puranas perspective and the Dharmic perspective. So therefore, I would not venture to get into that space for the simple reason that I do not have the competence or the qualification to add anything more than what they've already done for the discourse. So now let me start with this quote from the Mahābhārata itself. No person in this world can maintain himself without injuring other creatures. From the Shanti Parva, Bhishma is in his elaborate teaching to the Pandava king Yudhishthira says this in the Shanti Parva. Now, I thought this was the most appropriate thing to start my talk with, because whatever we do, invariably there is some element of harm to the other creatures. As a farmer tills the soil, there's a lot of harm caused to the worms, etc., which live in the earth. So therefore, that's the spirit where we actually start our journey of taking decisions faced with Dharmasankata. Namely, should we till the soil, which could cause loss of life to these vermin and the insects which live in it? Because in a Indian civilizational perspective, we believe Atma and Paramatma are there in all living creatures. So we do not actually recognize human species as being superior, like certain other cultures or civilizations look down at other species. So from that perspective, so therefore we start a journey that the life-giving food that we consume is invariably a process of causing harm. So therefore the Dharmasankata that we face to begin with is with taking life to sustain life. So therefore it becomes a perspective in the context in which we are looking to have this conversation. Now in this regard, I would like to start with this Medical Termination of Pregnancy Act 1970 and the rules in 2003. Here was a case, I would like to do my talk through a few judgments of the Supreme Court which deal with certain situations where the court is called upon to face a situation, as we would refer to dilemmas in decision making, which are akin to the Dharmasankatam we face in our day-to-day life as well. Here was a girl who was about 21 years old, was in a living relationship with a person, and she gets pregnant, and the middle of the pregnancy, he chooses to abandon her. And the law permits abortion legally under the Act till 20th week, and post 24th week, it needs an approval of the board. So the regular news items we keep hearing in the newspapers about women approaching high courts, seeking permission for abortion at a later stage, etc., is a claim by a prospective mother for her own mental health as against the unborn child's right to life. So that is the conflict that the prospective mothers who are actually carrying a life within them go through. And Indian law has always recognized the mother's prerogative as far as continuing with the pregnancy is concerned as a bodily autonomy, and it has been reiterated in multiple judgments. And the Parliament has also recognized this principle of the right of the mother to take the child forward, because it's her child and it's her responsibility to bring a life into this world and nurture it. So the mother has been given that right to take the decision at an appropriate stage, and then with certain safeguards which are inbuilt within the legal mechanism. In this case, the 24th week had just lapsed. The lady had approached the High Court, and for some reason the High Court did not pass an order permitting it, and then from 23rd week she moved on to the 24th week and the regime changes. Here the Supreme Court had to deal with two situations that were confronting it. The first situation was whether a single mother was also covered under the explanation provided under the Act, because married women were allowed to terminate post 24 weeks as well. But unfortunately, the draftsman somehow, either by inadvertence, did not specify that unmarried women or single women can also exercise that power. So the High Court exercised its jurisdiction and put the Government of India on notice that your statute seems to be discriminating between unwed pregnant women and married women. So while that challenge was pending, the interim relief was what was required for the lady. So the Supreme Court goes forward to adjudicate this conflicting rights and then harmonizes it as a principle of interpretation, that the right of a woman to have the child terminated post 24 weeks has been recognized by law as a matter of public policy. And it also, in the same provision, recognizes that a woman in marriage could, on account of becoming a widow or probably a legal separation from the husband, was also permitted to actually terminate pregnancy post 24 weeks. Because of the changed circumstances, the continuation of the pregnancy and to giving birth to a child would actually cause a further harm to the mother for her mental health, in addition to the physical harm that she could be put through in case of certain other medical situations as well. So the Supreme Court recognized this as a flaw in the drafting and then harmonizes the interpretation of a right of a woman to include a right of unmarried or married women to go through the procedure independent of their marital status. So this actually deals with the situation of a human, a 21-year-old who's living and working on her own in a metro, in a relationship, reaches a situation in life where she feels that she has other siblings to take care of and she cannot have the burden of a newborn child. So that is where the courts had to take in to factor in all these social and other implications, and then the court has also recognized the impact of the pregnancy on the mental health of the mother, the prospective mother, the petitioner in this case. So I think that's one glaring instance where life and death are chosen, because for us, as my limited understanding teaches me, that life comes in at a much earlier stage. When the life starts with the sperm which is successful in actually entering the woman's ovaries. So therefore, if that's the biological impact, so there was a life already and which is grown. So, and we have the stories of Prahlada, Abhimanyu learning from the womb. So therefore, there is life. In fact, Hindu succession laws also recognize the rights of the unborn child. So therefore, as far as life is concerned, it is already there. But the mother's health and mental health are given paramountcy, and therefore the unborn child's right were required to concede. So, I mean, so looking at this Shanti Parva maxim of Bhishma, so certain injury was bound to happen, and the larger scenario, the mother's health was given precedence over the child's. Now, moving on to a completely different terrain, in a constitutional democracy like ours, where we have a union government and state governments, and the territory of India is also defined. So Article 355 casts a duty on the union to protect states against external aggression and internal disturbance. So the article reads this way: it shall be the duty of the union to protect every state against external aggression and internal disturbance, and to ensure that the government of every state is carried on in accordance with the provisions of this constitution. The paramount obligation of the union government is to protect the territory of India as specified in the first schedule of the constitution. This is not part of Article 350. So now, once the union is having the defense as a part of its exclusive sovereign power within its domain, it is cast with the duty to protect the territorial integrity of the nation. The next right which I'm going to present is the Article 21 of the Constitution, which talks about right to life. This is the most comprehensive article of the Constitution, which deals with all aspects of a human life, including its need to have a livelihood, a clean environment, forests as part of the healthy ecosystem to live in, the ecological balance, and several other rights have been read into this Article 21 right. Because for us, life is not mundane animal existence, because we are species who actually are thinking and innovating and evolving with passage of time. So a preamble also recognizes this and then gives us the liberty of thought. So the liberty of thought gives us the power to think and expound the existing texts and also interpret them with changing times to meet the requirements by adhering to the Kala Dharma. In that sense, Article 21 is the most comprehensive right that the Constitution guarantees us. Now, faced with this right, now I would like to present the facts which led to a judgment of the Supreme Court concerning the Char Dham Yatra road project. The government of India proposed to develop the Char Dham Yatra routes in order to enable the increasing influx of pilgrims to reach these places as a part of the government's policy. They conceived this project, which involved widening of the existing roads in the Himalayan terrain. The Shivaliks are the lower, the Himalayan glaciers are the highest. So they are connected through these ghat roads, and people who would have traveled from wherever you are in the world towards Rishikesh, that's the foothill of the Himalayas, or the beginning of the Himalayan range. So you have to travel upwards from different states. We have access to Himalayas. This project, like most of the projects, were invariably tested before the environmental forums, namely the National Green Tribunal in 2018. The challenge was that the Himalayan range of mountains are actually very fragile and they're relatively younger as compared to the other ranges in the world. So they felt that excavation of these hills for expansion of the roads would cause damage to the ecology of Himalayas and also the flora and fauna, and then could add to the landslides and other related challenges that the Himalayan states already have. So this challenge was on a premise that the project of 900 kilometers has been split up into different parts so that the technical requirement of a larger environment impact assessment, etc., would not have to be undertaken by the government. And therefore, they've split up the project into multiple units to bring it below the threshold beyond which a larger environment impact assessment studies, etc., are required. The National Green Tribunal rejected these petitions, but however stepped in by constituting committee of eminent people from science who had the wherewithal and the institutions that they represent to study the project and also guide the implementing agencies to ensure that the damage to the ecosystem and the hills, the ranges, etc., is minimized, and also that the debris, etc., which is being generated there is also dealt with in a eco-friendly manner. So that was the scope of the committee. In the meanwhile, I would like to draw your attention to the third aspect which is happening parallelly. In 2017, the Doklam standoff between the Indian Army and the People's Liberation Army of China in tri-junction between India, China, and Bhutan happened. Thereafter, we are all familiar with the Galwan face-off, where we lost a few of our own beloved soldiers, and they inflicted enough loss to the Chinese side also, and there's been a standoff ever since May 2020. And we all know May 2020 was the first phase of Corona, where the entire world was in the grip of lockdown and not knowing where we would be heading from here. It was at that point of time that the attacks started. So that really was timed to perfection to meet their end goals. But our soldiers braved it and then defended our territory. Now, these conflicts of ecology, need for access to pilgrims, was also confronted with the additional challenge of providing good, reliable, all-season infrastructure for the armed forces to mobilize. Because these roads in Uttarakhand would actually also lead towards the LAC, which is the Chinese border. So though the action was happening somewhere near Ladakh and Sikkim borders, but the government realized that we cannot afford to have an infrastructure shortage when we all know the infrastructure on the other side of the border is pretty much in place for decades, and we were not really moving there. So this was also a factor which was brought before the court. And so we had two competing claims on one hand: the need for a better, stronger, reliable all-season infrastructure for the people of the state of Uttarakhand, for the access of pilgrims who've been traveling to Char Dham for centuries, as well as the need for the central government to mobilize its armed forces to places at short notice and quick movement. There were arguments raised which also included challenge to the need for a two-lane road leading towards the border areas. The challenge was that a single lane would be adequate for the army, and they were quoting an old statement of a former chief of armed forces who had said that the adequate infrastructure is there for us to mobilize. Obviously, no chief of army would make a statement in a media interaction that we do not have infrastructure to mobilize when you are in the midst of some action in another border with the same neighbor. So that statement was the edifice on which the activists tried to oppose the expansion of the roads. whereas the Ministry of Defense put across their needs to have parallel movement on both directions for the infantry and the artillery to move quickly and mobilize and demobilize as and when things evolve. So therefore, these were the conflicting positions that the court was required to decide upon. So the dilemma on one hand was the landslides, which we keep seeing and reading even now as we speak in Himachal and Himalayas. So that's a very perennial challenge that people are facing. On the other hand, the constitutional duty cast upon the central government under Article 355 to protect the territorial integrity. Now the question comes to us now at this stage is, what is the priority, or how do you harmonize this? So in this conflicting background, the Supreme Court balanced the conflicting interests by upholding the need for protecting the territorial integrity, as would be the case of a constitutional court, which is bound by the constitution, which talks about the territorial integrity of the country, as well as protecting the environment ecosystem as well, because it is an intergenerational obligation which has to be taken care of by the concerned authorities, namely the environmental ministry and others. So when we have these conflictive claims, now are we to do something which would destroy the future, or are we to balance it? That was the critical challenge that was faced, and the Supreme Court accepted the need for doubling the roads to single lane to 2 lanes, but at the same time also gave several directions to the committee to be constituted or under the NGT orders, and also reconstituted by the Supreme Court itself. Further, it also ensured that the rehabilitation program which happens after the construction, so that the ecology is restored and strengthened back to its original self, happens parallelly. So the balancing act was done so that we have our roads both for our pilgrims as well as for our armed forces, both for our dharma and desh, I would put it. At the same time, protecting the environment for all those who think beyond dharma and desh as well. So they are not really separable, but they are very integral to each other's needs and existence. So therefore, that was one kind of a decision making, which I thought I could share with this august audience. Now, the third one was a very interesting thing. This is a pure question of law that I would like to draw your attention to. When I say a question of law, here we're talking in terms of a constitutional democracy with the rule of law. The rule of law and an institution of judiciary in place. So the law mandates under the procedural laws or the substantive laws of the land that parties adhere to and comply with the judgments of the courts once they come to a court to get their disputes adjudicated. So once the adjudication happens, it is upon the parties to honor the outcome of such adjudicatory process, of course, subject to their availing all the legitimate legal remedies which are available to them. So the facts herein, I'm talking about the Bhopal gas tragedy. The intervening night of 2nd and 3rd December 84, a deadly chemical fumes escaped from the factory owned by the Union Carbide of India Limited in Bhopal. So this was a fully owned subsidiary of an American corporation. The Bhopal Gas Leak Disaster Processing of Claims Act 1985 was enacted by the central government. The act empowered central government to institute suits or other proceedings and to enter into a compromise. So if you recall, I was probably 10, 11 years old in 85. It was a horrific morning of 3rd when people got up to hear about what happened in Bhopal. So government at that point of time, as an economy, as a nation, we were not definitely a very strong economy. So we had our challenges. So in that situation, the government acted by enacting a law so that the people who are victims of this gas tragedy, those who lost their lives, those who were badly injured, and those people who could actually survive that but started showing symptoms much later. So all this large group of people, as the sovereign government, the government enacted this law to take up their cause in a representative capacity, that is, as the custodian. like the sovereign is the custodian of the individual citizens' rights. In that sense, the government steps in to take up this cause on their behalf. While this was happening, a suit was filed in the New York court against the UCIL as also the UCC. Their claims were settled. Those claims were rejected in the New York court on the premise that all the evidence would be in India and it is not feasible to hold a trial in New York for these causes. And Indian government, the central government, moved the district court in Bhopal, invoking the tortious liability principle against the companies. While this litigation was happening in India, in Bhopal, the dilemma before the decision makers was, what do we do here now? The country at that point of time did not have the resources, probably financially, to meet the requirements of the times. So the suit was filed with interim prayers were made, directions were given by the lower courts to deposit a certain amount of money. That was challenged for either side to the higher court, and the matters eventually reached the Supreme Court. So the Supreme Court had an occasion to deal with this in 1989. In 1989, the Union Carbide Corporation sat down with the central government and then negotiated a settlement. The negotiated settlement was for a certain specified amount of money as a liquidated cost or damages or the suffering on account of all those things. The parties had agreed at a particular amount, and that amount was put before the Supreme Court, and the Supreme Court acceded to that compromise settlement which was arrived between the Union Carbide and the central government, representing the individual victims and the deceased families. So that compromise led to a deposit of money by the Union Carbide, and that money came into the coffers, and then rehabilitation and other operations could be taken up under the statute which was already in place. In 1991, some private parties wanted to unsettle that settlement agreement by moving a review petition in the Supreme Court. The Supreme Court went into the review petition, and then the central government at that point of time in 1999 stood by the settlement and said the settlement will have to be held binding, because what happens is if you unsettle a settled agreement, the legal consequences, the parties will be relegated back to the position prior to the settlement, and they would have to fight their litigation by leading evidence on the extent of damage, on the quantity of loss suffered and other things. And all of this would take considerable amount of time. So the government of the day at that point of time chose to stand by the settlement, and the Supreme Court also upheld the settlement and rejected the review petitions. Then in 2010, the central government sought to reopen the settlement by invoking a much narrower jurisdiction than the review jurisdiction. So this is referred to as the curative jurisdiction. We refer to them as the curative petitions filed, and this jurisdiction has been a judicial invention where the court felt there could be situations and circumstances where a certain set of facts could not have been brought before the court at the time of its adjudication, or even at the stage of a review petition. So then what does the court do when certain facts emerge thereafter? It was in this background that the court was called upon to create a remedy or an avenue for exceptional cases to be brought before it in a curative petition. The central government sought to invoke this exceptional jurisdiction in 2010. That is nearly about 9 plus 10, 19 years after the review petition, and whatever time from 89 when the judgment on settlement was passed. The Supreme Court declined to entertain the curative petition filed by the government of India. It went into the foreign exchange fluctuations, the Indian rupee becoming weaker. So financially, there was not really much of loss in that sense. Of course, the court also agreed with the Attorney General's submission that the foreign exchange, etc., would not really inure to the benefit of the foreign corporation. But the Supreme Court had to stand by a constitutional principle of upholding the judgments of the court and making the parties to be bound by them. What happens is, if in a constitutional democracy where we believe in rule of law, that is, that the law will protect those who follow the law, they were required to give a verdict on an issue which had international ramifications as well. Because in a globalized economy and world, how your judiciary functions is a very critical component for people to assess the vibrancy of a democracy. Because if the judiciary is not holding up the principles which are accepted universally, namely verdicts of the highest court of the country, are to be honored and cannot be reviewed in a very cavalier or a casual manner, would we go a long way in either inspiring confidence of the citizen of the country or foreign nationals who would like to deal with the country in various transactions, both civil or commercial or otherwise. So in that sense, the court chose to uphold the need and the necessity of providing sanctity to the settlement, which was arrived at consciously, having regard to the facts, circumstances, which were all within the knowledge of the person concerned at that point of time. The political parties in government may come and go, but the government of India continues as a continuing entity. So therefore, the commitment of the government of India would hold the ground, and it cannot be negated, much less can it be actually undone at the behest of the government of India itself. I mean, just look at the situation here. Someone comes to a compromise, he agrees for things, takes the money, goes back for 20 years and comes back and says, sorry, the compromise was not right. I would like to reopen it and I need more money. So, I mean, this is exactly what it boils down to. And the Supreme Court said, sorry, definitely it was a very great tragedy, but we need to also balance the need to have the rule of law, which follows certain principles of certainty of judgments, and the parties being bound by these judgments. So it is in this context that the court had to come to this conclusion. Now, I mean, having spoken about the various conflicts and the dilemmas that the decision-making process we are faced with in day-to-day hearings, I could only think of this maxim. There is no act which is entirely pure, nor any that is entirely simple. In all acts, right or wrong, something of both prevails. This, in fact, is also part of Shanti Parva. This is when Yudhishthira is in a state of despair after the war, seeing his entire family virtually decimated, his children, grandchildren, his cousins, his uncles, guru, everyone is decimated. So he is living in a very miserable state. So Arjuna, along with his siblings, each of them has a conversation with Yudhishthira, cajoling him and then explaining to him that what you did, you had to do. There was no other way, because you had to do certain things in order to uphold Dharma. And in the process, invariably, there will be something which will be not to our liking, and it will not be as a simple solution that you do something and there's no harm to anybody. Invariably, what we do, invariably there's some kind of a harm. I mean, to put it on a very simplistic perspective, every day morning, I have this Dharmasankata, that should I sit down to read or I go for a walk? So ultimately, it's a choice that we have to make, whether to choose one over the other. So the choice is not easy, and definitely this is something we will have to deal with and probably engage with in our life on a regular basis. So therefore, the title that I actually opted, was Dilemma in Decision Making, because Dharmasankatam sounds very profound. But in our day-to-day lives, invariably, we are actually faced with situations like this, where we are required to take those decisions, which invariably cause the consequences of our acts to our disliking or liking. So that's something I think we all have to deal with on a regular basis. So on this note, I think I would only be grateful for the opportunity to share my thoughts in this forum with scholars. And I was wondering, like, having three Sridhars and then the minion sandwich between two giants was definitely, I'm sure, put myself in a real Dharmasankatam to what do I speak in the presence of these scholars. And thank you so much, INDICA Academy, and thank you for this opportunity.
Thank you, Sridhar Garu. In fact, the center which Meghji is leading and the center which is organizing this conference focuses on law and jurisprudence, and we have three law and jurisprudence related scholars today. Aditi Banerjee ji,
Yes.
yourself, and Sri Lakshmi Peddada ji.
Yes.
And deservingly, and to our luck, good fortune, you covered these legal issues in such a erudite and subtle way, very meticulous analysis of the cases. That was a really very good addition to the symposium, which we very badly required. And but for you, that gap would not have been filled today. Thank you very much for that contribution. Your book also on Mahābhārata was a very good contribution, and this time it is not Itihasa Purana kind of material, it is all your professional material.
Yes.
So naturally, you did excellently well. Thank you very much for this.
Grateful, sir.